Now, Pavoratii was a good friend.
Hello. Welcome to The Revealing. I'm your host, Pavoratii. I'm here to discuss the I-04 case. As a disclaimer, this channel is for entertainment purposes, and these are my opinions. Well, my opinions are pretty good. And I'm not here to slander anyone. I am here to blow this internet completely wide open with this one, though, folks. You are not going to believe what old Pavoratii finally found. But before I do that, we got some new court docs, and very important ones, because this one has set the trial date for Bryan Kohberger. Not only that, it set the schedule for all of the pre-trial motion hearings. And I think it's important for us to understand when things are going to happen and what those things are when they happen. And, I like to break things down a little bit more than just reading you some court docs. I'm going to go through what's important, and I'm going to explain things that you need to understand. Then we'll discuss the trial date. And then when I'm done with all that, and don't y'all fast forward to the end of this video, but when I'm done with all that, we're going to move on to part number 2, which is a bam, bam, bam. I got a double bam, bam for you in this one, folks. I'm about to blow the internet up with this one, I'm telling you, but do not fast forward. Let's do this in order, okay? And then I've also got, part 5 of my series that I'll be doing later this week. But let's just get right into those court docs and talk about the hearing and what we can expect going forward in this case. Okay, so we've got this new doc, and you'll see that it is hereby ordered as followed. And they vacated all the previous trial schedules for these new ones. I'm not going to read this all to you. I'm just going to read what I feel like is important that you probably want to hear. They're not telling us today that the jury questionnaires are going to go out, but the voir dire shall commence on July 30th. That's where they bring in the jury members and they go through the process of selecting the jury. The jury trial shall commence on August 11th, 2025 and run through November 7th, 2025, inclusive of the penalty phase. So that means that includes, if he's found guilty, the penalty phase. So a trial will begin each day at 8:30 a.m. and conclude at approximately 3:30 with a lunch break of 45 minutes. So not a lot of trial time in there, Judge. Monday through Friday. The parties should be aware that some trial weeks may need to be shortened depending on other obligations of the court. So if the judge has a golf game scheduled, then they won't have a trial that day. Counsel should have sufficient evidence, witnesses ready to go each day to utilize the full day's trial schedule. Why don't you just make it 8 to 5, Judge, and maybe you'll shorten the trial up a little bit. I was going to take off for the trial next year and cover it for everybody, but I'll be danged, August through November. I mean, that's my busiest time of the year. So, I don't know if I'll be able to do that or not, but we'll see. But there we have it. August 11th, 2025, this thing's going down. Now, a final pretrial conference will be held May 15th. That's to make sure that, they've got everything in line to start the trial. Then we got our motions. Now, the death penalty motion, they got to have everything in by October 10th, and I don't think we've seen any of the state's responses yet to the motions. The defense has filed, so by October 10th, which is in 2 days, they're supposed to have that in, or might be one day. Today's the 9th. That might be tomorrow. The defense's reply briefs are due by the 24th, and then we're going to have a hearing on November 7th at 9 a.m. So there's our first hearing. Now, the discovery motions. Last day to file motions to compel regarding any known unresolved issues is November 14th. Now that's kind of huge, right? So all those motions to compel discovery that the defense has filed, if they're going to file any more, they got to go through those gigabytes that they just received and make sure that they don't need anything else because they have to have it filed by November 14th. Responses are due by December 6th. Replies are due by the 20th of December, and then a hearing on discovery motions, and that'll be a final hearing on discovery motions. And that's January 23rd, 2025 at 9 a.m. So that'll be the biggest hearing that we'll have between now and the trial. Well, possibly when we get into the ICR 12 rule motions, those may be the biggest. But that'll be a huge one for the discovery because in that one, if all the discovery isn't presented to the defense, that's the one that the judge will impose sanctions or not impose sanctions on. So that's a big one. Now, Rule 12, ICR motions. All motions governed by ICR 12, including motions to suppress evidence, are due by the 14th of November. Pretty quick. Responses by December 6th. Replies by December 20th. January is going to be a packed. Oh, look at this. January 23rd, 9 a.m. January 23rd, 9 a.m. Okay, so they're going to do all the discovery motions, these motions to suppress. Let's take a look. Motions in limine. Yep, the motions in limine will be held April 3rd at 9 a.m. Okay. All right, so, but, whoa, that's a huge court date. January 23rd, 9 a.m. for the discovery motions and the motions to suppress and all the other ICR motions. So let's take a look at the other, what the Rule 12 ICR motions are, because that's something we need to understand. Okay, you see Idaho Criminal Rule 12, pleadings and motions before trial, defenses and objections. And we're not going to read all of this. It explains what they are, but a pre-trial motion, any defense, objection, or request which can be determined without trial of the general issue may be raised before the trial by motion. The following must be raised prior to trial. So when he's talking about those Rule 12 motions, it includes motions to suppress, but it also includes all of this. Defenses and objections based on defects in the prior proceedings in the prosecution. Ooh, so all those prior proceedings John Judge resided over, they can go over defenses and objections based on the defects in those hearings. All right? Defenses and objections based on defects in the complaint. Ooh, that's big. Indictment or information. Other than that, it fails to show jurisdiction of the court or to charge an offense, which objections may be made at any time during the pendency of the proceedings. So if they were going to go for a motion to dismiss, this would also be the time for them to do that. And apparently this is the time for them to go after the complaint and the indictment and the information. This is going to be a huge hearing, folks. Motion to suppress evidence because it was illegally obtained. Request for discovery under Rule 16. Rule 16, remember, that is the confidential informant rule. Request for severance of charges or defendants under Rule 14, severance of charges. That's if you have two defendants, right? You'd sever the charges of the two. Motions to dismiss based on former jeopardy. So if they'd already been charged once, you can't be charged twice. All right, then we get to the motion to suppress. A motion to suppress evidence must describe the evidence sought to be suppressed. Well, you mean like the DNA on the knife sheath? And the legal basis for its suppression sufficiently to give the opposing party reasonable notice of the issues. Well, I think they both have reasonable notice of the issues regarding the DNA evidence, but I think you're also going to find, as I show you later in this video, motion to suppress witness statements and informant's reliability, and all that's going to come up in this hearing as well, folks. You are not going to believe what I found. Motion date. Motions under Rule 12B must be filed. Okay, it's talking about the rules on when everything can be filed. Ruling. A motion made before trial must be determined before trial. So he's got a rule on it before the trial. And then it talks about the effect or failure to raise defense or objections. But those are our Rule 12 ICR motions that he's discussing. So that hearing is going to be huge. Okay, now we got again the motions in limine and notices under IRE 404B, 608, and 609. Motions in limine and similar motions notices are due by February 10th, responses by March 3rd, replies by the 17th, hearing on the motions April 3rd at 9 a.m. So that'll be another huge hearing right there in April, and that'll be right before the conference hearing in May. And then the big dog in August. Defendant's discovery deadline for the discovery. The defendants must turn over to all their discovery to the prosecution on how they're going to, the evidence that they're going to use to defend the Kohberger. That's all due by January 9th. I don't think that's changed much. And expert lists. Yeah, of course, the expert list. It talks about the guilt phase, jury questionnaires, copies of exhibits, guilt phase, lay witnesses. Okay, those are just all the deadlines for the witness list and everything they're going to need to have. But let's talk about our motions in limine and notices under IRE 404B. Okay, Idaho Rules of Evidence, Rule 404. Character evidence and crimes or other acts. Again, we've already gone over this in the past, but the character evidence. Prohibited uses, evidence of a person's character or traits of a character is not admissible. So that shouldn't even be discussed in a motion. Exceptions for a defendant or victim in a criminal case. Exceptions for a defendant or victim in a criminal case. Remember, who are the victims in this case? Well, the judge has declared the victims are only the Ethan, Xana, Kaylee, and Maddie. But I think as far as the criminal rule goes, that could be extended to the victim's family. And when we're talking about character evidence, crimes, and other acts, if it is extended to the victim's family, whoa. Look at this. A defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. The defendant may offer evidence of an alleged victim's pertinent trait of character, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. In a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. Well, I don't think we have any problems with the victims as far as that goes, but if the victims extend to the families, well, then that's a difference. Exceptions for a witness. Evidence of a witness's character may be admitted under Rules 607, 608, and 609. Wow. That is what they're discussing with the witnesses, the informant's reliability, folks. It's going to get real. Crimes, wrongs, and other acts. Again, prohibited uses is evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. So permitted uses, notice in a criminal case. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. In a criminal case, the prosecutor must file and serve reasonable notice and do so reasonably in advance of trial. So if they try to come up with, some kind of a wrong or other act, I mean, we've discussed this in the past. I'm not going to dive into that real deep. But exceptions for a witness. Evidence of a witness's character may be admitted under Rules 607, 08, and 09. Now, what were we looking at? IRE 404B, 608, and 609. So there you have it, folks. We got a trial date set, and we've got some big things that are going to happen between now and the trial. So we've got the dates for everything, and we'll see what comes out between now and then. Now it's time to get into the second part of this video. And for those of you that have been with me for a long time, you know that I've pulled a lot of information off of the federal records for criminal offenses. Unfortunately, I have to go through those and really study them to try to identify the players in this case in those records, because it won't identify them in the records. So based on that, though, some claims that I've made that, you know, Mr. TF would be considered an FBI informant. And the mother of one of the victims in the case, Miss CK, I have in the past speculated that she was an FBI informant. We've got into the Fetty Bros and all the other scenarios. But I also mentioned that according to that record that I found that I thought probably was her, that her snitch card would have been full after or right before the atrocity. And they released her from all of her federal charges and therefore turned her back to the to the wolves. And she would no longer be considered an informant. Well, those were my speculations. There was no way I could verify that at that point. But you know, I've been diving and deeping and looking high and low for things, and well, I'll be danged if I didn't find a couple of things that I think are going to shock you. Let's take a look. Now, I always thought that Moscow, Idaho had the key to this thing, and then I went to Coeur d'Alene, and they had a key, and that was a big key, but I always suspected that Spokane up there held the real keys. Now, you'll see this is the mother of one of the victims in the case, and this is in reference to an arrest on January 31st, 2023 for failure to appear, and she was arrested up in Spokane. So, boy, a lot of these people seem to end back up in Spokane, and a lot of things seem to happen in Spokane, doesn't it? But let me just point out something, because I mentioned that right before the atrocity, I felt like, based on the records that I'd found, that her snitch card was full, and they had turned her back over to the wolves without any protection. And you can see right here in this, I want to point this out, right here under the state ID and the county ID, okay? Does everybody notice that? Okay, and this is January 31st, and she's to be released on February 9th of 2023, and there's the county and state ID, right? Nothing fishy about that. But when we look at TF, we'll notice something a little bit different. See, when I found TF's record up there in Spokane in the Superior Court, as you can see, he was arrested, like I've said, on November the 22nd, 2022, and he's scheduled for his first appearance. And you're going to notice something under the state ID that looks a little bit strange on TF. And folks, that's a bam, 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 bam. But just in case that's not enough for you, see, here's another arrest up here in Spokane. Well, I'll tell you what, Miss K stayed in Spokane a lot. This was back in April of 2022, when she still would have been active with that informant role. And you can see here again, oh, there it is. This is when she was active, folks. So once again, and folks, that's a bam, 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 bam. So when Pavarotti's on the case, he's pretty stubborn. I know there's a lot of people out there that follow me and have been giving me a lot of praise, and I appreciate you all. especially my subscribers. One mention I could mention my subscribers a lot more that have supported me, and yes, y'all are very important to me, and thank you all for your support. There's also been a lot of naysayers out there. Oh yeah, I seen one putting out a video that's like upcoming, talking about, I think he called it Joke Embry and Evil Circus or some nonsense. Well, there you go, buddy. Keep sniffing up that Jack D tree, guy, and let me solve this thing like like the grown-ups do. So that's all I got to say in this one, folks. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. Till next time, Pavarati's out.